decisions of the European Court of Human Rights are binding, strictly speaking, only on respondent states to those cases. The court might say, we would like all the states to take notice of this, we would like them to give effect to these principles, but other states are not strictly legally bound by them internationally, so it doesn't make sense to make them bound by them domestically. That doesn't mean that they have no role, of course. Both sections 2 and 3 of the ECHR Act talk about the convention and the decisions of the convention decision-making bodies as being guides to guides for domestic law and domestic courts. Our courts will give them due judicial notice and take due regard of them. And I think it would be fair to say, as is the case in the equivalent provision in the UK, that we might say they're presumptively binding on courts. So we would presume that the courts will follow the principles laid down in the jurisprudence, although they're not stricto sensu required to. And the presumption is useful because it means that in situations where the decisions of the court are not appropriate for very good reasons for domestic law, a court can deviate from them. And that's what happens in the UK under 3 broad headings. So the decision, the jurisprudence of the court in Strasbourg is not clear, which unfortunately is often the case. The decision from the court in Strasbourg would give rise to extreme practical difficulties. And that is one of the reasons, by the way, within the convention, why only the respondent state is bound. 47 different legal systems, you have to have some leeway, some flexibility about how it would work within each system. And the third reason, which came to the fore in the Horncastle case, which you might be familiar with around hearsay evidence, is that the decision is not carefully considered. In other words, it's wrong. Or it doesn't properly understand the domestic legal system that it's dealing with, and that does sometimes happen. Now, the final thing about saying that those decisions are not binding is that that should mean, as a matter of logic, that not only are our courts in domestic law not obliged to go as far as the Strasbourg court, but also that they can go further than the Strasbourg court. So there is that famous Ulla principle, no more and certainly no less than what the convention protects. But it's clear from the parliamentary debates, and particularly the submissions of Brian Lenihan, who represented Michael McDougall in a debate in the Seanad, that the government envisaged our courts being able to go beyond the European Court of Human Rights. So it's consistent with the legislative scheme. It's also consistent with the nature of the ECHR Act as domestic law to be interpreted by domestic courts in a domestic context, and it's consistent with the idea of the convention, which is the laying down of minimum standards across a diverse set of states, with those states then being able to go further where they think it appropriate. So perhaps at some point we will get to revisit Mr. Justice Fennelly's view in McD and Dell that Irish courts can't go further than the European Court of Human Rights, even where there's a clear trajectory of cases towards a certain end point. There's a reluctance to do that. So far in problematising the Act, I have identified a couple of areas where I think we have uncertainties or a problematic lack of clarity. But I promised you an optimistic Friday feeling at the end. So I have a 5-prong Friday feeling on page 10. It might be a Friday feeling for me. I'm kind of suggesting that you guys go and do the work to make this happen, so not so much Friday feeling for you. The first one is that if Section 2 is approached from a maximalist perspective, so real interpretation up, in the real sense, the guidance sense of the word, it really could create an enormous transformation in the extent to which people get to enjoy convention rights on a daily basis in their interactions with the state. And so I think that Section 2 holds great potential there if we can harness it. The second prong is that if the Supreme Court takes, I meant to write expansive, and I wrote expensive, it might also be expensive, Pullen-like approach to the savings clause of Section 3, even if that's not literally required, that could catalyse a really important cultural shift within organs of the state that would again bring the convention closer to people in their practical interactions. I didn't speak about this in the paper, I forgot it, but injunctions, if injunctions were given as a Section 3 remedy, we do see them given for administrative decisions under Section 3, like in Boda, but in Pullen, the court was reluctant to give an injunction because she felt that this piece of law was still in force and she ought not to enjoin an organ of the state from exercising it, and I think that was quite logical. But injunctions would be, on a kind of a real life basis, the ideal remedy for a finding of a breach of Section 3, because it would stop the breach in real terms. The fourth point is that while declarations of incompatibility have a sentimental and communicative value, they are not effective, and perhaps we ought not to spend so much time, academically at least, that's all people seem to talk about, thinking about the declaration of incompatibility. And the final point is that the ECHR Act is Irish law, to be interpreted by Irish courts, and we therefore ought to embrace this act and embrace this potential to not only ensure that the minimum standards laid down by the Convention are enjoyed here in as much as the Act permits, but also, where appropriate, that we go further than that, because this is domestic law and we can make of it as we will. Thank you.